Hey everybody, Arizona attorney David Ina Wilton here, and in this video I want to talk to you about a slight tweak we have in Arizona child support calculations. In order to talk about what I'm going to talk about, I first need to lay some groundwork, so let's talk about the backdrop of what happens in a child support modification. So this is assuming there's already a child support order in place. The court's already gone through and ruled on child support. There's an order for somebody to pay child support, and this has been going on for a bit. Normally speaking, anytime somebody wants to come back and change that, make some sort of a modification to the existing child support order, you have to show that there's a substantial and continuing change in circumstances. In other words, something's really different from the way it was before that justifies coming in and reopening the child support order and putting in a new order. By the Arizona child support guidelines, that substantial and continuing change in circumstances for child support purposes is defined as a 15% change in the amount that you're paying. So as long as you can show that there's something different that's resulting in a 15% change from the previous order, you can come in and modify, put in some new order that has a different amount from what you had previously. The interesting tweak came from a Arizona Court of Appeals case that was published in March of 2018, which was revolving around this idea of when these substantial and continuing change in circumstances exist. Now, previously there was an understanding, and this is the case in spousal support or spousal maintenance situations, that when you're looking at this substantial and continuing change in circumstances, you kind of take the previous order and what was going on at that time and looking only at what's happened since then. You can't go backwards. So you can't say there was something that preceded that order, something that led up to the order that changed, that has resulted in what's going on now that's feeding into our substantial and continuing change in circumstances. Sort of conceptually makes sense. Well, this new order came out in Bernstall v. Bernstall, which the Court of Appeals said that one of the things you can have in a child support situation to modify the existing child support order that would justify a substantial continuing change in circumstances, so long as it hits the 15%, is showing mistakes in that previous order. So I'll give you an example. Let's say there's a child support worksheet in place and it has one of the parties showing $100,000 in income. And then that support order is entered based on that $100,000 in income. And then roll forward a little bit. We've been sitting on this order for a while, and now it turns out that the other party finds out that person actually had $150,000 in income. Now that could change the child support equation based on this new number. So just on that piece of information, even though it preceded the entry of the previous order, you can still use that as justification for your substantial and continuing change in circumstances. The one cautionary note here, if you're looking at a prospective change, that is to say you're sitting there in a situation and maybe you're contemplating, do I make a fuss about this piece of information right now, thinking you could come back and try to change it later, is the effective date of the child support order. So having that piece of information as your substantial and continuing change in circumstances, something that preceded the existing order, does not change your effective date on something going forward. There's not going to be a new effective date for the new child support amount until you go in and file it and change it. But in a nutshell, that's the new change. It came out of this case called Bernstall v. Bernstall, and as always, if you have any questions about any of this stuff in terms of your legal rights and obligations, it can be very complex. I highly encourage you to at least talk to an attorney just to understand your basic legal rights and obligations.